Firstly, I would like to extend a very sincere thank you to the conference organisers for the kind invitation. For those of you who don't know me, my name is Emma Goodwin and I work on medieval French literature and history. I'm preparing the publication of my doctorate at Oxford University on conceptualising national identity in old French epic poems dating from the end of the 12th century. Today, I would like to discuss 4 aspects relating to crowdsourcing in the context of data protection and COVID-19 challenges. The structure of the talk is as follows. I'd like to begin by looking at the potential for online collaboration in citizen science crowdsourcing projects, the ways in which crowdsourcing and social engagement interrelate, using the example of the public transcription competition I organised at the University of Luxembourg, based on one of my digital projects, Crowdmap-the-Crusades. I'd then like to go on to talk about data protection regulations and the recent fallout from the Schrems II judgment at the European Court of Justice. Related to this are the short-term and medium-term challenges for academic projects involving data transfers between the UK, EU and the US. I'd like to end by discussing the possible reorientation of existing and future projects to accommodate data protection and COVID-19 constraints. So what is crowdsourcing? Well, on the slide you have 2 definitions. The first I'm working with because it remains a succinct and applicable definition for all crowdsourcing projects, and the second because it resonates with the experience of the public transcription competition on October the 5th last year. Pausing for a moment to unpack the way in which crowdsourcing and social engagement interrelate, the idea is that crowdsourcing uses social engagement techniques to help a group of people work collaboratively towards a common goal, but relies on sustained input and more effort than just socially engaging, which may be transitory or something that happens only once. It is an important consideration for the crowdsourcing field because users want the same, if not more, social interactions than they had in pre-digital days. This has particular relevance during the Covid-19 pandemic, in which society is increasingly obliged to use digital means to socially engage, with consequences for all our activities. Motivation lies at the heart of successful online collaboration, and citizen science crowdsourcing projects need to attract and motivate volunteers. If we consider the factors motivating volunteers to collaborate on a project, there's significant overlap between virtual and real-life environments. Factors pertaining to live volunteering, set out by Holly in 2010, also apply to the online environment. Whether in person or online, the desire to socially engage remains constant. These factors include enjoyment, interest in learning new things, contributing to a worthy cause, desiring to volunteer and give something back to the community, helping to achieve a group goal, or to attempt a goal or problem that's so big it's a challenge. Some things which noticeably increased volunteers' motivation, according to Holly, were raising the bar, increasing the challenge or end goal, creating an environment of camaraderie so that volunteers felt part of a team and could give each other support and help, being very clear about what, how and when things should be done, acknowledging volunteers in various ways, rewarding high-achieving volunteers and being able to see progress of the big goal and their place within it. All these things are challenging to achieve without collecting personal data or personally identifiable data in an online environment, whereas they may be easier to navigate in a socially distanced live setting. Continuing to consider online environments, it's useful to look at what has proved successful in improving online collaboration. An interesting development in this field in recent years, which goes to the heart of this desire on the part of users to have more social interactions, can be seen in the advent of the use of gamification in crowdsourcing. Games led upon crowdsourcing tasks have emerged, and these are known as human computation games, games of the purpose, or crowdsourcing games. Morchoiser et al. In 2016 investigated how gamification has been used in different types of crowdsourcing and established from their investigation that it had been an effective approach for increasing crowdsourcing participation and the quality of crowdsourcing work. The use of badges, which can be virtual, has been used to encourage collaboration rather than individual achievement. Lee et al. In 2017 looked at the perceptions of virtual reward systems in crowdsourcing games, arguing that virtual reward systems were a fundamental mechanism in crowdsourcing games, and they looked at how they evoked intrinsic motivation, perceived enjoyment, and output quality. By looking at crowdsourcing location-based content, across 3 different types of mobile application, a track, badge and share version, they commenced an experimental study. The track version offered a points-based system for actions such as contribution of content. The badge version offered different badges for collection, while the share version served as a control, which didn't have any virtual reward system. The results showed that badge and track enhanced enjoyment emotionally, cognitively, and behaviourally. Richter, Raban, and Raffaeli in 2015 argued that badges provided a kind of social shaping because they represented interactions that are shared among people who hold them. In contrast, points were typically used to indicate an individual's progression and performance, and hence were likely to evoke self-efficacy and foster direct competition. And that was observed by Hamari in 2015. We can see, however, successful combinations of both approaches, badges and points, in the global not-for-profit initiative ICO Community, which was created in 2013 by serial entrepreneur Xavier Niel and has various partner organisations around the globe, including 42 Silicon Valley, where it's the leading college for software engineering, coding and programming, and promotes successful peer-to-peer learning through using virtual houses to foster a sense of affiliation, and a virtual reward system using badges to reward collaboration when students help one another, and to penalise individual attainment in the sense that students cannot get badges and progress without first helping their peers to learn. Before leaving the idea of virtual badges, another way of rewarding participation and cementing a sense of belonging may include giving participants branded merchandise, such as a free t-shirt with the event logo. This could be compared to a form of group identification and was a strategy that I used in the live crowdsourcing event I'm going on to discuss next. Turning to the example of Crowdmap-the-Crusades, this is a project that's been going on for 7 years now, which tweets out single lines to transcribe from the unpublished portion of an anonymous Old French Bodleian manuscript, Hatton 77. It dates from the beginning of the 13th century and is the oldest and most complete version of the text. It's 16,000 lines long, written on parchment, and includes one illustration featuring a scene from the siege of Jerusalem, in which 2 youths are assisting 2 archers by preparing to pull on ropes to catapult a cauldron of fire. It's known under various names, including the Siège d'Antioche, the Esdra d'Antioche, and the Song of the First Crusade, and was written by an Anglo-Norman scribe. The narrative follows the First Crusade from the Council of Clermont in November 1095 to the Battle of Ascalon in August 1099, and it's identical to nearly all of the Latin First Crusade accounts. So how does crowdsourcing fit into the project? Well, an algorithm is used to tweet pictures of 2 lines at a time via Twitter from the second half of Bodleian Hatton 77. Users are directed to the website with 1 click and can type their transcription in the text box beneath the excerpt. Transcription can also be done via the website. Participants submit anonymous transcriptions, which are emailed to an expert moderator panel for checking and correcting. Last year, I was tasked with organising an event for the inaugural ICO Community Day. ICO, formerly the Information Systems and Controls Association, is a global not-for-profit which helps to advance the positive potential of technology. And the aim of the first ever Worldwide Volunteering Day was to make a meaningful difference in wide-ranging ways across communities around the globe. Local chapters worldwide had to volunteer to do an activity, and as I was General Secretary at the time for the Luxembourg chapter, I suggested using Crowdmap-the-Crusades to hold a public transcription competition and to combine that with a roundtable discussion on online safety and cybersecurity risks. The challenge was quite vast in that we had to transfer an activity which had to date taken place in a virtual environment into a live event. We had 2 months to organise the event from start to finish, and we had to create enough interest to attract enough volunteers. Creating an online leaderboard or other virtual reward system seemed impossible within the time frame. The audience for such an event wasn't one which would necessarily be interested in transcribing lines from an old French manuscript. And in light of the GDPR regulations, I decided it would be easiest not to collect any personal or personally identifiable data from the participants beyond what was required by the waivers they had already signed. The approach taken was that participants signed printed copies of waivers and an online waiver organised by ICO headquarters. They all received a free t-shirt with the ICO Community Day logo. And I designed a competition on paper and gave the participants numbers. We came up with peer-reviewed solutions for the competition, and I invited colleagues from the Sorbonne and Heidelberg universities to evaluate the competition during a roundtable discussion. Over a reception following the event, the winners were presented with prizes. We had a few observations, which were that all 20 participants except one took part in the competition, even though they were mostly interested in cybersecurity. All 20 participants stayed for the entire event, even though it was held on a Saturday afternoon. One of the participants made a video of the event, which you're now watching, and there have been requests to repeat the event again next year. It's clear that in the context of the current COVID-19 challenges, depending on your jurisdiction and the restrictions at your home institution, there may be a preference for holding virtual as opposed to live events. However, before embarking on research which requires the collection of personal data or data which is personally identifiable, it's definitely worth considering recent developments in the field of data protection which may impact your project. Now I'd like to go on to look at two key points in this area. One relates to a judgment which is to come regarding the adequacy of UK data protection laws and how that will affect data transfers between the EU and the UK after the transition period. I'd also like to talk about the recent Schrems II judgment at the European Court of Justice and how this is impacting EU-US data transfers. So to begin with the first point, if the EU makes a formal adequacy decision that the UK data protection regime offers an adequate level of protection, there will be no need for specific safeguards. However, if the transition period ends at the end of this year without an adequacy decision, there will not yet be such a decision in place. So in practice, this means that EU senders of data need to make sure that other appropriate safeguards are in place if they're transferring data to the UK, probably through a contract or other binding legal instrument or by making their own assessment of appropriate safeguards. Schrems II is a judgment that took place this summer and relates to an action, or a case rather, that was brought by an Austrian lawyer, Maximilian Schrems. He's very well known. He's an author and a data protection activist who has now brought 2 cases against Facebook, which have had seismic consequences for existing data protection regulations. The first legal challenge in 2015 led to the invalidation of the EU-US Safe Harbour framework, and the second this summer struck down the EU-US Privacy Shield, much as it did the Safe Harbour EU-US framework in 2015. And the reasons given were a lack of individual redress and lack of proportionality. This judgment has an immediate consequence for current UK-US data flows. Although the UK formally left the EU on January 31st, nearly all EU law continues to apply in the UK, including the jurisdiction of the European Court of Justice, until the end of the transition period in December 31st. This means that companies or institutions transferring data from the UK to the US were previously able to rely on the EU-US Privacy Shield until the end of this year. But this is no longer the case following the Privacy Shield's invalidation. So the Schrems II judgment immediately disrupts UK-US data flows, and organisations will have to use alternative safeguards like standard contractual clauses or binding corporate rules. There are 4 ways in which the judgment impacts the UK and specifically EU-UK data flows. First of all, as we've said, the UK-US data flows are immediately disrupted. And secondly, the room to manoeuvre in seeking unrestricted data flows with both the US and the EU has been diminished. Also, the The EU adequacy decision for the UK has been made less likely, although not impossible. And finally, the standard contractual clauses used to transfer data from the EU to the UK may be vulnerable in the longer term, which could potentially result in serious disruption to EU-UK data flows if the UK fails to attain an adequacy decision. Whilst the EU-US Privacy Shield arrangement, which includes thousands of participating companies and institutions, is now invalid, the Court of Justice of the European Union did uphold the validity of standard contractual clauses. However, there must be protections in place in the third country to which the EU data is transferred, specifically with regard to access by public authorities and judicial redress. The court issued a news release stating that the limitations on the protection of personal data arising from the domestic laws of the United States on the access and use by US public authorities were not so circumscribed in such a way that satisfied requirements essentially equivalent to those required under EU law by the principle of proportionality, insofar as the surveillance programmes based on those provisions were not limited to what was strictly necessary. In particular, the court said that the ombudsperson mechanism in the US, a role which had been created by the Privacy Shield arrangement, didn't provide data subjects with any cause of action before a body which offers guarantees at the level of EU law. The court said that the ombudsperson, which sits under the US Department of State, is neither empowered nor independent at an adequate level. One of the lawyers arguing the Schrems case before the ECJ, Herbert Hoffman, the law professor at the University of Luxembourg, stated, and I quote, "The European Court of Justice has invalidated the Second Commission decision violating EU fundamental data protection rights. There can be no transfer of data to a country with forms of mass surveillance. As long as US law gives its government the powers to vacuum up EU data transiting to the US, such instruments will be invalidated again and again." End quote. The courts also clarified that the EU data protection authorities have a duty to take action and highlighted that they are required to execute their responsibility for ensuring that GDPR is fully enforced with all due diligence. Up to now, many DPAs have taken the view that they have unlimited discretion to look the other way, but the court has now put an end to this practice. So, in practical terms, this means that standard contractual clauses can no longer be used by Facebook and US companies that fall under US surveillance. Companies can't just sign the standard corporate clauses, but they also need to check that they are being complied with in practice. Despite this, despite the invalidations made by the judgment, absolutely necessary data flows can continue under Article 49 of the GDPR. So any situation where users want their data to flow abroad is still legal, as it can be based on the informed consent of the user, which can be withdrawn at any time. Equally, the law allows data flows for what is necessary to fulfil a contract. This is a solid basis for most legal transactions with the US. In simple terms, the US has now been brought back into the normal situation that the EU has with other third countries, but it's lost its special access to the EU market over US surveillance. We move on now to look at short-term and medium-term challenges for academic projects involving data transfers between the UK, EU and the US. The key questions for researchers to ask are, firstly, whether their existing projects include the collection or analysis of personal data. And if you want more information on data types, data controller processor definitions in the context of academic projects, if you look online, I presented on this for the Data Privacy Day in 2020 for the University of Luxembourg, and in the slides I have set out those definitions specifically for researchers. The second thing to consider is where the data is stored and whether any software has been used which includes data transfers which previously relied on the Privacy Shield or standard contractual clauses. And if so, where is the data being transferred? Is it being transferred outside the EU, and are there implications for the project if there's no UK or EU adequacy decision next year? The key person to talk to in your home institution is, of course, your data protection officer, or any others who are tasked with being responsible to advise in this area. If the standard contractual clauses are still valid or not, it's also worth considering whether there's a way of reorganising the project to minimise data transfer if this is an area where you think there may be issues depending on either the judgment that's just gone this summer or the one that's to come next year. If you can't see any solution, or you see challenges by these two judgments, it's always worth considering whether it's possible just to stop collecting personal data in the short to medium term, particularly if the data isn't the object of study per se, but it's ancillary to the main research focus. Finally, when considering how we might accommodate data protection and COVID-19 constraints, again, the first questions to ask are making sure that you are aware of what type of data you're collecting and where it's stored, and whether you can revise the project plan to accommodate the current uncertainty, or whether you need to pause it until the situation's clearer. Certainly, as far as the EU-US adequacy decisions concerned, the US Secretary of Commerce Wilbur Ross and the EU Commission have indicated a willingness to work together. And if the two sides can reach a new agreement about what constitutes adequacy, the court's decision states that the finding of adequacy will ensure the lawfulness of transfers to the US unless some future court decision holds otherwise. Clearly, we're operating as researchers against a backdrop filled with uncertainty, with a legacy of research practices built upon established channels of cross-border data flows, collaboration and innovation. But in the light of recent developments in data protection regulations and the political uncertainty over adequacy judgments regarding data flows, perhaps a period of contemplation and reflection accompanied by a revision of existing projects with those responsible for data protection in your home institution will be worth considering, at least until these decisions are made and implemented, and we can once again move forwards fleet of foot. Thank you for listening.